Fellow Ghanaians, good morning. In this digital age, our phones and computers have become extensions of ourselves. They are our classrooms, our offices, our means of communication and connection. The internet has given us power and freedom that generations before could only dream of. It has become the great equalizer, a space where a child in Boko can learn the same course as a student in Harvard, where a trader in Kanishi can sell to someone in Toronto, and where citizens can hold their governments accountable in real time. But like every good thing, it has also come with some dark side. Cyber fraud, impersonation, harassment, stalking, blackmail, and the exploitation of children have become all too common on our internet. Our cyberspace, once a place of creativity and opportunity, is increasingly becoming a playground for crime and abuse. It is understandable, therefore, that a government will want to tighten the laws to make our online space safer. The Cybersecurity Amendment Bill of 2025, which is currently being spearheaded by the Ministry of Communications is an attempt to do just that. Its stated intention is to deal with the legitimate and growing problem of all these online issues that we have, cybercrime and abuse. It seeks to give the Cybersecurity Authority more powers to respond to and prevent these crimes. On the surface, it looks like a necessary and timely reform. The Minister for Communications, Sam George, clearly means well when he pushes this bill. It's right to be worried about the safety of children online, the rise of cyber fraud, and the way in which technology is being used to harm people. These are real problems that cannot be ignored by any serious government. However, as with many well-intentioned policies in this country, the devil always hides in the detail. The bill in its current form risks creating more problems than it solves. It turns what should be a framework for protection into a potential weapon for control. It gives the Cybersecurity Authority powers that goes far beyond technical regulation and enforcement. It allows the authority to act as investigator, prosecutor, and in practice, as judge in certain circumstances. Under sections 4A and 59B, the authority, CSA, under this bill, will be able to investigate, prosecute cyber crimes, freeze property, and confiscate assets. Under section 20B, its officers will have the same powers as police officers, including the power to arrest, search, and seize. This is not some small matter. It means a regulatory body, which was meant originally to provide policy guidance and coordination, could now wield near police powers without the same oversight and accountability mechanisms that guide law enforcement. It blurs the line between a regulator and the security agencies. And when lines like that blur, abuse becomes not just a possibility, but inevitable. And even more worrying, Section 59C allows the authority to demand information from anyone, journalists like me, private companies, even individuals, with criminal sanctions for refusing to hand over those information. Failure to comply could mean imprisonment for up to 2 or even a fine of 10,000 penalty units. A penalty unit is 12 cedis, by the way. So think about that. A journalist like myself refusing to disclose a confidential source, a company protecting client data, or even a citizen declining to hand over personal messages could go to jail. That is not cybersecurity. That is coercion that we are wrapping up in a legal document. Again, sections 59D through 59I make things even more chilling. They allow the authority to obtain secret court orders. Yes, you heard right, secret court orders to access or seize computer data without notifying the affected person, ex parte. There is even a clause allowing inspectors from the Cybersecurity Authority to enter and inspect computer systems and premises without a warrant, so long as they give 7 days notice. That's all. These are sweeping powers that strike at the very heart of our own right to privacy. The digital footprint of a citizen, emails, photos, personal messages, should not be open for inspection by the state except under strict judicial supervision. History, if anything at all, has shown us that once governments gain the power to pry, they rarely give it back. But perhaps the most dangerous part of this bill lies in Section 67A, which deals with cyberbullying and online harassment. No one disputes that we must protect children and vulnerable people from predators and bullies. But within the same section, there is a clause that criminalizes the deliberate spread of, quote, false or misleading information intended to, quote, deceive or manipulate. On paper, that sounds reasonable. Who wants lies in the public sphere? But the real question is this: who decides what is false or misleading? In a country where political debate is often heated, where government criticism is too easily branded as disinformation, such vague laws become powerful tools of censorship. Under subsection 10, this so-called offense carries a punishment of up to 5 years in prison or a fine of 25,000 penalty units. Imagine a blogger posting an unverified report about a minister or a citizen tweeting a mistaken claim about corruption. Suddenly, they are not just wrong, they are criminals. This is how democracy dies, not always with some coup, but with a law that is written so broadly that it criminalizes dissent under the guise of protection. Fellow Ghanaians, it is one thing to fight cyber criminals, but it's also another to give the state the means to watch, intimidate, and silence its citizens. The irony is that Ghana already has laws that cover most of these issues, from the Criminal Offences Act to the Electronic Transaction Act to the Data Protection Act. The laws are there. So what we lack is not law, but enforcement. We do not need a new set of draconian powers. We need competence, accountability, and investment in cyber forensics and education. The silver lining is that this bill is not yet law. It is still in the consultation stage, which means there is time to fix it. But consultation must mean more than publishing some press release. It must mean sitting down with all involved: journalists, lawyers, tech experts, civil society, and ordinary citizens. It must mean acknowledging that cybersecurity is not just about policing, it's about protecting citizens' rights. A government that listens will not lose authority, it will gain legitimacy. The public is not the enemy of the state, we are its backbone. When citizens raise concerns about overreach, they are not obstructing, they are participating. Consultation is democracy in action. We can build a robust cybersecurity regime without eroding freedoms. We can protect children without infantilizing adults. And then we can strengthen our law enforcement without creating digital police state. What we need is balance, a law that secures the digital space without suffocating a scene, one that upholds justice without undermining liberty. Ghana's greatness, this country's greatness, has never come from the silence of its people, but from their courage to speak truth to power. From the days of Kwame Nkrumah, the days of Abdul Malik Kweku Bakon, Kwesi Pratt, Anas Aremi Yao Anas, our progress has always depended on the freedom to speak, to write, and to question authority. So, fellow Ghanaians, we cannot build a secure nation by eroding the very freedoms that make it worth securing. The internet must remain a space for innovation, expression, and opportunity, not one of fear of censorship and silence. We must consult with honesty, we must legislate with restraint, and remember that in the end, the goal of cybersecurity is not control, but protection. Because when we lose our right to speak freely online, we lose a bit of ourselves, and democracy itself becomes under threat. So, to the Honorable Minister for Communications, you may mean well, but the concerns people have expressed online, on X in particular, by civil society organizations, that this bill risks criminalizing speech, eroding the gains you have made in our democratic space, are well-intentioned. We have to listen, and we need to fashion out a bill that has the right ideas in them. Before they get to Parliament, a lot of these must change. Consultation must mean something. The tone of our leaders when engaging around these must reflect that the people are the true sovereign and the leaders, their servants. Good morning, fellow Ghanaians.